Good morning. Welcome to the Utah Court of Appeals. We're here today to hear an oral argument in the case of Tilleman versus Tilleman. Case number is 20210637. If I could have counsel enter their appearances for the record, please.
Julie Nelson for Appellant Michael Tilleman.
Good morning.
Andy Wright and Jessica Anderson for the Appellee Michael Tilleman.
Good morning.
Good morning.
Thank you for being here this morning. You all know the drill, I think. So looks like 3 minutes have been reserved for rebuttal. Do I have that right?
Yes.
Everything been arranged?
Yes.
All right. Any questions or concerns before we begin? Okay, Ms. Nelson.
Thank you, Your Honors. Good morning. I'm going to start with a couple of key facts. In 2017, the father reported his concerns to the police, who reported it to DCFS. In 2018, father took the child to Dr. Penman, who was concerned enough that he reported to DCFS. In 2019, father took the child to a different doctor who assured father that if he was concerned about physical injuries, he should report to DCFS. In 2020, father took the child to an ER physician who reported the injuries to the CJC. Now, meanwhile, mother had stonewalled the conversation. Even though there was a court order in place, she refused to discuss the injuries with father. So father felt like he had very little option when your child comes home with injuries that are not the normal scrapes on your knees and your palms and your shins, but on your eye and in weird places. Father felt like he had no option. Now, that's what we do have. Let's talk about some things that we don't have. We don't have mother ever reporting emotional abuse. We don't have DCFS ever ruling out abuse. We don't have DCFS investigating father for emotional abuse. We don't have DCFS telling father that he's making false reports. And also, we don't have evidence of harm. All that the other side has shown in terms of harm is that at one point, DCFS told father that he didn't have to report every scratch because it can cause trauma over time. Not that it had caused trauma, not that it did cause trauma, but it can. And Dr. Penman said at one time that the taking the child to the doctor was making the child very self-conscious, but then on the stand he clarified that that was because he had misunderstood someone else's report and then in fact her anxiety was mild. That's it. Now, their brief has a powerful narrative that lacks cites to telling us other harm. There was no expert testifying that there was harm. There was no therapist. There was no guardian. There was no special master. Nobody came up and talked about what harm the child had actually suffered. So the trial court relied on its own view of the fact that reporting injuries or taking a child to the doctor is bad, and that it causes emotional abuse. Now that position is unsustainable under Utah law, and it is unsustainable by the evidence. It also completely ignores the actual physical abuse or the actual physical injuries that were seen. Now, we have a problem under Twitchell. Under Twitchell, this court held that where a trial court is presented with large amounts of evidence and ignores it, or doesn't say anything about it at all, that's reversible error. And that's important here because we don't know if the trial court just thought all of this evidence, and not just the evidence of the emotional harm, but evidence on other factors. We don't know if the trial court considered it and found it irrelevant. We don't know if the trial court didn't consider it at all. We don't know if the trial court maybe forgot that it happened because the trial court didn't talk about it. So we have an error under Twitchell, and I think on that point alone we have reversible error. I also want to think about the policy, the precedent that this case sets. If a parent is concerned about their child's physical injuries and the other parent has stonewalled the conversation, what is the parent supposed to do? And if they were to start looking in Utah law about what they were supposed to do, they would see that they're a mandatory reporter. They would see that they have criminal liability for not reporting, that they are immune from civil liability for reporting. They might hear doctors telling them that it's okay to report. They might find the definition of harm in the child welfare statutes, which, by the way, is vastly different than the harm we're dealing with here. The harm in the child welfare context says that talks about emotional damage that results in a serious impairment in the child's growth, development, behavior, or psychological functioning. We don't have any of that here. And just last winter, the Supreme Court in Re AB, it was really more of a procedural issue, but did talk about that statute and noted that the juvenile court did not make findings that would show that the child had suffered serious impairment under that statute. Now, I'm not saying that that statute is controlling here, but it certainly is a data point when we're talking about what a parent should do. Another thing we might think about is, what is a lawyer supposed to tell a parent if a parent comes in and says, I am concerned that my ex-spouse is abusing my child? Is the lawyer supposed to say, don't report because you'll lose custody? No lawyer should say that. No lawyer's going to say that. But that's the reality of the case that this trial judge has set in front of us.
Can I ask a question about the scope of your appeal? You're not appealing the joint physical custody determination, right?
Right.
The 35.1 arrangement, you guys are okay with that, at least you didn't appeal it.
Correct.
What you're appealing is the sole legal custody.
That's exactly right.
And what you're asking for as a remedy is a remand, or are you asking us to impose joint legal custody, or are you asking us to impose sole legal custody in favor of your client, or exactly what do you think the remedy is for that?
Well, I think the most likely remedy is a remand for another factual analysis. If you would like to switch custody, that's all right. But
You'll accept that, I
I'll
suppose.
accept that, but the more, I understand that.
So but the reason I'm asking is in terms of assessing sort of the context of the way you challenge these factual findings and the way the court went through the factors, we should be thinking of those in terms of the legal custody dispute, not necessarily the physical custody issue.
Right. And so Section 30-3-10 and Section 30-3-10.2 are the same when we're talking about legal and physical custody. They don't differentiate. And 10.2 says that the factors in 10.2 and the factors in 10 are mandatory. And the trial court misunderstood that. It's true that Section, I'm just going to call it 10, 30-3-10 says that the trial court may consider the following factors. But 10.2 says it shall consider the following factors and the factors in 10.
And if the legislature meant that discretion implicit in may in the prior section controlled, instead of saying and the factors in the other section, the court would have said and consider the directive or something more vague. But by specifying it's the factors that are to be considered, your position, as I understand it, is for these cases, the word may is effectively written out of the prior subsection.
That's exactly our position, and I don't think the plain language allows any other reading. 10.2 is using mandatory language, and therefore it's mandatory. And if the legislature wanted to do it differently, it could. It can, but it hasn't. So if we assume then from that position that all the factors in 10 and all the factors in 10.2 are mandatory, we also see under Woodward that they are supposed to be comparative, meaning you're not just supposed to lay out evidence about one parent, you're supposed to compare both parents. We know from Twitchell that you're supposed to actually address all of the evidence presented. Now, the other side has criticized that the trial court's not obligated to recite all the evidence. That's true. That's not the position that I'm taking. The position we're taking is that the trial court was presented with significant evidence that was entirely overlooked. And so it's made a legal error in the way that it applied the factors. This isn't a factual challenge. This isn't a marshalling issue. This is look, you didn't address all the mandatory factors, you didn't do them comparatively, and you've ignored significant amounts of evidence in the emotional abuse and also in other factors.
You acknowledge, don't you, that the emotional abuse argument you led with is a factual issue? Or do you not concede that?
Well, I agree that it can be a factual issue, but what I would argue here is that two pieces. One is that the trial court has failed to follow its mandate under Twitchell and in terms of identifying all the physical evidence that this was in context of. It's ignored significant pieces of evidence. It's looked at things not in context. And I would say that those are not challenges to factual findings. Those are challenges to the way that the findings have been presented.
Okay. Can I ask you about one of the issues you've raised with regard to Dr. Zelig? Am I saying his name right? I don't know.
Good enough, as far as I know.
As far as you know. Okay, the first issue is this DeBry versus Goetz issue. And I guess I wonder if, I realized that there was a motion in limine filed to exclude Dr. Zelig from testifying, so the admissibility of the testimony was preserved. But did anyone ever ask the trial court to apply DeBry versus Goetz?
I believe, I don't know the answer to that question. But what I do know is that,
And if not, then don't you have a preservation problem?
no, because first off, we don't have to challenge all of the relevant law. What absolutely was preserved was challenging that the evidence shouldn't have come in, the evidence biased the court, the evidence.
Well, all right, but there's two issues. I'm acknowledging that the question whether Dr. Zelig should have been able to testify ultimately was preserved.
Yes,
There's a separate challenge that you're making, as I understand your position. The separate challenge is, aside from the admissibility of his testimony, there was this issue about him being able to see the records.
yes,
Yeah, and what you're saying is, well, that there should have been a reasonable certainty inquiry, and then there should have been an in-camera examination under DeBry versus Goetz. And it doesn't appear to me from looking at the record that anybody ever asked the trial court to do that, though the dispute below with regard to these records was with regard to their relevance, but nobody ever asked the court to make a reasonable certainty determination. Nobody ever asked the court to do an in-camera examination of them, as I understand the record. And if I'm wrong about that, I'd love for you to point that out.
I will look for a record site during the appellee's argument, but I am confident that that we asked the trial court to prevent Dr. Zelig from looking at the records. We know that that's true because the trial court then issued them under a protective order saying that they couldn't be
Right.
widely
But
disseminated.
Preservation then depends on what ground you asked for that on, right? You can say objection to a piece of evidence on relevance grounds, but that doesn't mean you have preserved an objection on hearsay grounds, right? The
No, that's
grounds on
right.
which you objected is what
Okay,
we look at for
that's right.
preservation.
But what was preserved was an objection on privilege grounds, and that's the issue. And DeBry gives us a method for handling that,
Right,
but
but if you're the trial judge and we were to reverse and say, hey, trial judge, you didn't apply DeBry versus Goetz, he's gonna go, well, nobody ever asked me to. Come on.
I think what we would ask is to reverse and say that you violated father's privilege by releasing all of these records. That issue is absolutely preserved, and that the records shouldn't have been disseminated to Dr. Zelig.
Before you sit down, can I ask a question?
Yes.
On the attorney's fees, it seems that your brief embraces the idea that attorney's fees for enforcement and attorney's fees generally are two different things and have different things for the district court to consider. But I believe then your argument goes, but the court just awarded all our fees, so we're good.
Well, not that we're good. So our argument is that the trial court used both the substantially prevailed standard and the regular enforcement standard
Right.
combined,
Right.
didn't segregate which fees were applicable to which. And that is the exact same thing that happened in Connell. And this court reversed and said you have to distinguish which fees are tied to enforcement and which fees are tied to establishment. And when the trial court goes back to do that, I think it will find that very few of the fees could possibly be tied to enforcement. That's the only place where the substantially prevailed standard is applicable. To the vast majority of the case, substantially prevailed is not relevant, and we need to be looking at mother's need and father's ability to pay. And we have argued in our brief as to why the trial court got that wrong. Does that answer your question?
Was that issue preserved?
Yes. And you can look in the two places that you could certainly check for preservation would be, there was a post-trial brief that was essentially written closing arguments. And a post-trial motion. The post-trial motion is at $2,400 and the post-trial brief is at $2,202.
And the objection was specifically made that there should have been that kind of allocation. We require that, for instance, when there's a claim that brings contract claims and tort claims, and there's a contract that provides for the prevailing party on the contract claim to get its fees. And the cases are, I guess I will say the cases are legion that say, well, you've got to allocate which was what. Occasionally those will be inextricably linked and they can't really be separated because the theories are so close. But otherwise, the party seeking fees is expected to account for which fees were incurred in connection with the recoverable work and which were not. And not only do you argue that that should have happened here, but you're telling us that that specific request and that objection was made when the other side requested 500,000 fees, and I've got 160,000 some odd instead.
What happened, I understand your question. What happened was the trial court came out with its findings saying that mother substantially prevailed and here's my needs analysis. Our post-trial motion says substantially prevailed is not relevant in an establishment proceeding. And which is absolutely correct, that it's not relevant in an establishment proceeding. And that's the argument that we made in our opening brief. It's not relevant in an establishment proceeding. In their response brief, they said, well, some of it went to enforcement. Well, if that's true.
But they didn't say, and those fees are set forth in Appendix A.
Right, that's right. That was not broken out. And if that was, that was their obligation to do that. The trial court instead just threw both standards at everything. Thank you.
Thank you, Ms. Nelson.
Yes, please. Mr. Wright, sorry, Judge.
Mr. Wright,
Mr. Thayer's my partner.
got it.
I'm here today. Thank you. May it please the court. I do want to start off, Judge Orem, you raised a couple of questions on fees. The appellee, my client, Michael Tilleman, set forth and delineated between enforcement and establishing fees orders and set that forth to the court. That was established and broken out by my client in the trial court record. The court.
And did the enforcement fees come to at least 160,000?
The enforcement fees, if I recall, were somewhere in the 80 range, 70 to 80 range, if I recall correctly. And the rest of the fees were for establishment.
But the question is, doesn't the trial court have to engage on that?
Yes.
And the fact that your client does it.
I agree, Judge Mortensen, and I think what you find in the record here, and I think it's different from Connell. Connell specifically talks about, granted, a 15% in the language of the decision, talks about conflated the two standards. Judge Brady of the district court specifically, after receiving our delineation of fees for both standards, stated she substantially prevailed on everything, and then it went through a needs, ability, and reasonableness standard as well. And so in this, he didn't conflate the two standards. What he did, he analyzed both standards, set it forth pretty clearly in his findings, I think pages 24 to 28 of the decision, and then awarded fees and knocked them down for reasonableness as he thought, which I think in many times in enforcement actions too, the court will always apply reasonableness standard to the fees. And that's what Judge Brady did here. And I think under Connell and the fee statutes, both of them, it was appropriate. I don't think you can conflate it, but when all fees were awarded, both from enforcement actions as well as establishment, I think it was proper to articulate both standards, talk about the fees, and then cut them down for reasonableness, which the court did. And that's our position on the fees, Judge. I want to make sure I cleared up that issue. I want to go back to the beginning, what was raised, and I think this is the problem that we see, and the reliance on Twitchell can cause this. Twitchell, decided in 2022, cites to years and years of established great case law by this court, talking about litigants and appellants who come and selectively cherry pick evidence and ask the Court of Appeals then to essentially weigh that evidence, say this is really big evidence. The court didn't look at this and didn't like my evidence, but this is big stuff, and the court needs to reverse. Schumann Court, which is again reiterated by and Taft as well, and Allen and Lay, all these cases, Schumann Court held that appellant selectively highlights evidence from the trial record, asserts the evidence supported a different outcome, and claims the court's findings were inadequate because they did not specifically address his highlighted evidence. Our position is that's exactly what we have here. Is it the Court of Appeals' role now after Twitchell to say what is significant, what is not significant? Let me tell you what we do have in response to the appellant's presentation. What we do have is 28 separate reports by father to DCFS, to various police agencies, to various medical providers. Our position was that he was shopping around, going to one and going to the other. Judge Brady heard all this meticulous evidence over 10 days. Many witnesses, lay witnesses, medical providers as well in the records, and came in. And they were, each and every one were unsupported. That's what we do have. We have that each and every one were unsupported. Judge Brady found in his very detailed findings of 33 pages, 100 paragraphs of discrete findings, and then a very good summary, in my opinion, on page 2021 of why he was choosing legal custody, a summary of the evidence. And he found that these were false reports. He found that father lacked the insight to see that these reports caused abuse to E.T., the child, and to mother, paragraph 53 of the findings, if you want to look at that, where the court found that. That's what we do have. What we don't have before this court this time is marshaling. I think even under Twitchell and all these cases, there is still the need to come before the court and do a marshaling exercise. As opposed, sorry, Judge.
The main argument, I'm sorry to interrupt, my apology. There is, unlike many cases, a rather specific legal argument made by the other side, namely that if you read the two statutory subsections together, the court was duty-bound to consider each of the factors enumerated in both sections. And it was legal error not to do that. If that's right, and that's something we look at without deference to the trial court, if the trial court didn't properly understand its mission under the statute, then we would remand for the trial court to do what it should have done in the first place. That's a very different exercise than the court made a bunch of findings and there's been no challenge to the sufficiency of the evidence to support those findings. And so, and that is a factual, very deferential kind of review. But the very precise statutory legal argument is sort of what has my attention.
Judge, great question, and we spent a lot of time preparing for that. The statute 2019 was amended, that shall language in 10.2, which is the best interest factors, limited A through I, nine factors, whatever it is. And then they put the shall, visit those, and then in 10, which is you shall consider the best interest. And this is, Judge Harris, you raised the question of legal versus joint physical custody, legal custody, which in 10, deciding any form of custody, and then 10.2 is the best interest. But it specifically says in 10 that it is may consider the other enumerated factors. What do you, and I think this is intentionally done by the legislature to mirror the years and years of case law.
But the second subsection doesn't include the may.
I think it could have been clearer, Judge, I really do. I think it should have said, because of the problems that you'd have if you were to, quote unquote, as Allen says, a checklist. Twitchell even says there's not a checklist. What do you do with each of the factors at the very end of each one of those subsets? It says, and any other relevant factor the district court may decide. What does that open up to be? I mean, where's the checklist stop? And I think the legislature probably could have done a better job in 10.2 saying, and shall follow the parameters of section 10. But what you do have, even after 2019, in Twitchell and other cases, saying there is no mandatory checklist for determining custody and parent time, unlike other types of situations, because it is individualized. Over and over again, it's individualized. And if you were to require that every time, I think it opens up to a lot of problems. I think it opens up to problems where you would, district courts would be unable to fully go through the record. Might as well throw the trial transcript in there at some point, what it would require.
So if we determine that we like Ms. Nelson's statutory interpretation better than yours, and we determine that the district court really did not mention 3 factors, do we have to remand at that point? Is it a mandatory remand at that point?
Judge, I don't think so. I don't think so because, again, I think what Lay says, and ultimately what this court's role is, not to go back and, as said in Twitchell, not to go back and require a global accounting of all evidence presented, which I think it would be required if all the factors, but what it's supposed to do is to see if the district court sufficiently detailed, included enough subsidiary findings to disclose the steps by which ultimate conclusion on each factual issue was reached. Put another way, findings are adequate when they contain sufficient detail to permit appellate review to ensure that the district court's discretionary determination was rationally based. And I think from here, our position is clearly from the district court's very lengthy, detailed consideration of the evidence, making comparative findings on the strengths of the parents with respect to the best interest of the child. Judge?
If they're making a comparative analysis, and even if they're lengthy, 1,000 paragraphs, and they only mention as to particular considerations one spouse and not the other, then aren't we in a hard place, regardless of their length, to say that it was truly a comparative analysis?
That's an interesting question because you see Woodward's 2013 and Twitchell cites to it in a footnote back there, but the comparative type analysis that Woodward talks about, you don't see in a lot of other cases since then. And I think that if the Court of Appeals goes down the path of saying, okay, each and every factor has got to be considered, and each and every factor you've got to lay out 2, 3, 4, 10 pieces of evidence on each one to be able to do that, or where do you stop? Our position is if you look at the evidence, and again, this is highlighted by, I think, the problem of the appellant, there's selective evidence in cherry picking. On the factors that the appellant did raise, on the 4 factors of,
Well,
sorry, Judge.
Go ahead, finish your.
I was going to refer again to the Allen versus Allen case in 2013. If you go back and look at that case, the Allen court was kind of presented with the same situation where the father didn't really look at emotional stability, I think it was, or what emotional soundness, whatever it was. And the court looked through the findings, although they weren't delineated specifically under each factor, and found facts that the court put in its findings and records that go to those. I think that's what we have here in this record as well, where Judge Brady made such thorough findings, and I would point it to those ones that definitely support the findings that are challenged on appeal.
So the question I asked you a minute ago is it a mandatory remand if we agree with Ms. Nelson's statutory interpretation and conclude that there were 3 factors that the court didn't reach? And let me dive a little deeper on that.
Sure.
2 of those factors, ability to provide personal care rather than surrogate care, and previous parenting arrangements in which the child has been happy and well adjusted, those factors seem entirely geared toward physical custody. Right? The question of who's better able to provide personal care rather than surrogate care, what difference does that make to legal custody? Same with previous parenting arrangements. In other words, there's some of these factors that seem like they're all about physical custody rather than legal custody. And if the dispute here is about legal custody, what would be the point of a remand for the district court to say anything about these 2 factors in particular? I guess what I'm asking is there some sort of prejudice-based or other harmless error kind of thought that we could employ that would avoid the necessity of a remand for seemingly no purpose?
Judge, I think you've articulated it well. I would agree with that. I think on the issue which Ms. Nelson stated, that physical custody is not being challenged. And if these factors, which is alleged were not addressed, go towards that, it would be harmless error, so to speak. But I want to make sure that the court understands, if you look at the record, personal care versus surrogate care was addressed, both parties. And we have said it in our brief, mother's been the care, this is the father complained that the court specifically did into that they were not sufficient findings. Mother's been the caregiver since birth. Mother gave it full-time employment. Both parents exercised time. Paragraph 29 of the findings. Father employed full-time. Paragraph 98. Father's not missed many chances. So they talk about, in Judge Brady's findings, he did address this. And I think that's there. Same thing with moral character. We have, I think, obviously they addressed quite a bit about father, his moral character, but the judge did enter findings that I would argue relate to mother's moral character. And specifically, if you look at paragraph 34, 29, 77, 78, look at the 20 to 21 pages, 20 to 21 of the findings, talking about how mother has consistently participated meaningfully in the face of the allegations of abuse, how she reacted. I would argue, as the Allen court did, that the court could definitely find that goes to her moral character. Previously, parenting arrangements. Court addressed that at the very beginning of the case. There was talked all about how father was not involved in the first while of the child's life. Mother has been. That's been addressed. That's in the findings. And I think that the court, Judge Harris, if the court wanted to, it could certainly find it's harmless error if they were not addressed. I think they were addressed. And the court did a very good job of trying to be very detailed and thorough to go through all the factors.
Do you have any input for us on the question I asked about whether DeBry versus Goetz was brought up to the trial court?
Judge, I was one of the trial attorneys on this. What had happened is the parties did stipulate to a Rule 35 examination. Father did raise the issue, did not want his medical records released. There was briefing and several hearings before the court on that issue about that they were material and relevant. We wanted them. The court determined that they were and issued an order. And in the order specifically.
Well, at those hearings,
yes,
did anyone?
I don't have a recollection of whether DeBry was raised or
Did anybody ask for an in-camera review?
Judge, I don't recall if that was specifically brought up, but what was brought up, and I found last night, refer to the record, 735, that Judge Brady said in his ruling in which we moved to compel the signature of the releases to get the records, saying that the parties will follow Commissioner Patton, the commissioner at the time, his orders with respect to protection of the records. And if anybody is unhappy with how Commissioner Patton decided that, meaning the protections in place, what would govern the release of the records, they could bring that up with the commissioner or between the parties. So I think the court was saying there, if you're unhappy with the protections or what we're going forward as far as protecting the records, you could certainly challenge that, bring that up. And to my recollection, it wasn't brought up again on any sort of in-camera issue. But on the DeBry case, I would argue, as we did in our brief, that those steps were related to, we said enunciated with respect to a criminal case, but analogous protections in a civil case. Notice and protection of the records. And I don't think you can argue we don't have that here. It was argued extensively, the relevance and the materiality of the records. It was an order in place with the opportunity to challenge that. A protective order was put in place to govern the release and use of those records, which they were. They were used at trial. They certainly were material. Judges, I thank you for your time, and we would ask that the district court's decision ruling be upheld, affirmed.
Thank you, Mr. Wright. Back to you, Ms. Nelson.
Thank you, Your Honors. I want to start with Twitchell. Twitchell says, determining which factors may be tricky, some will loom larger in one case than others, but a court's factual findings are adequate only if they are sufficiently detailed and include enough subsidiary facts to disclose the steps by which the ultimate conclusion on each factual issue was reached, and where significant evidence concerning a particular factor is presented to the district court, findings that omit all discussion of that evidence must be deemed inadequate. That's where we are. We are also looking at Woodward, which is very clear that the findings have to be comparative. So I'm going to push back a little bit on Judge Harris's question, suggesting that we're really only looking at those couple of things that are related to the legal factors, because I see this as being a big umbrella. First off, the trial court came right out and said that it viewed 30-3-10 as optional. That was wrong. And then we have many factors where the trial court only talked about father and not about mother, despite significant evidence being presented. And that's what we're doing here. We're not cherry picking evidence. We're showing that you missed a bunch of information. That's what we have to do when we're doing this kind of analysis to say whether the trial court addressed things. And there are certain factors that the trial court didn't address at all. Now, counsel in their brief and even in argument has suggested that, well, some of the factors can kind of be implied. We can kind of pull these things together. I don't think that's what the case law is asking. Now, Judge Harris, I understand the global question of, well, is this like a technical default? Is Ms. Nelson just asking for us, if you miss a factor, that you have to get a remand? I don't think that's what we're looking at. I think what we're talking about is when there's significant evidence on a factor that could affect the overall decision. Do we need a remand? I think we do. And I think we need to tell trial judges, we're serious. We want you to go through the factors. They're mandatory. We want you to do it comparatively, and we want you to consider all of the evidence. Now, there are other factors that we didn't talk about. For example, there's one about keeping siblings together. Well, this kid doesn't have any siblings. So that would be a completely irrelevant point, right? That would not warrant a remand.
But I gather that you would prefer, with the section in mind, that each of those factors be addressed, and that here the court would have said, this child has no siblings, therefore factor 6 or whatever it is inapplicable here.
Sure, but if they hadn't, I wouldn't have appealed that.
Right.
Right? And, you know, on the emotional abuse, they're asking us about emotional abuse, but we don't have any analysis of the physical injuries. We don't have any analysis that they didn't warrant doctor's reports, none of them, not even the ones where a third party reported them, right? We've got the police, we've got the doctor, we've got the ER reporting them to DCFS. There's no discussion of that whatsoever.
Well, isn't that because the trial court, correctly or incorrectly, sort of took the totality of those many referrals, and I assume it's a more or less accurate list there on page 3 of Appellee's brief. It sort of looked at the body of those and concluded excess reporting.
But then it went the next step and decided that that constituted emotional abuse. Now, excess reporting and emotional abuse are, unless this case says that they're the same, they're not the same. That's what I was trying to convey, that there's a big gap in there. We need some kind of harm. And they don't have any evidence of harm. They haven't pointed to any evidence of harm. Their brief has this powerful narrative that doesn't have cites, and they don't have expert evidence of that. So are we saying that, well, I think that's excess reporting, I'm going to take away your legal custody, right? Like, is that what this case is going to stand for? I don't think that that's what we want this case to stand for. I think we need, if we're going to say excess reporting leads to harm, we need some kind of evidence of harm, and we don't have that. Now, as to the Dr. Zila question.
Did we have
Sorry.
expert testimony
Nope.
linking this up? Saying
Nothing.
in my professional opinion, it wouldn't be a medical certainty necessarily, but consistent with the standards of MSWs, that degree of excess reporting constitutes emotional abuse. Because I guess I'm wondering if the judge was using that in a somewhat more colloquial sense and didn't mean it as a term of social science art.
Let me pile on that question if I can. I know that makes it difficult for you, but that seems like what the judge was doing. And the judge didn't have to find emotional abuse in order to award sole legal custody to mom, right? The court could have just said, you know what, 28 reports, it's a lot. Father's being unreasonable. He can't co-parent effectively. This is not a situation where joint legal custody is going to work. I got to give it to one parent or the other, so I'm going to give it to mom. It doesn't have to make a finding of emotional abuse to get to that point, right?
Your question, was there an expert? Absolutely not. Your question, does he have to? No, but he did. And that's important because it's the first factor in 10 and 10.2. Child was emotionally abused by father. Now, if we knock that out, if we were to say, no, child wasn't emotionally abused by father, father made excess reports, then does that affect the rest of the decision? Does it affect the parent time decision? Does it affect the legal custody decision? But this is the point. The findings have all these just legal errors. We're not using the plain language of the statute. We're making an emotional abuse finding when really there's no evidence of harm. We're ignoring some factors. We're making non-comparative factors. I would say that that whole analysis is done incorrectly, and that's why we're asking for a remand. It's not just those couple of little factors that maybe are tied more to physical abuse. If the findings have that many problems, they're reversible, they need to be done correctly. If there's no emotional abuse, then that needs to be removed from any sort of analysis.
All right,
Thank you.
thank you, Ms. Nelson. Thank you, Mr. Wright. Appreciate you coming down and helping us understand this case a little bit better. We'll take the matter under advisement, as we almost always do, and we'll issue an opinion as soon as we're able to do so. Thank you. Court's in recess.